Good morning, my name is Hae-sun Kim, advisor of Gangnam Labor Law Firm. Today with Labor Attorney Jung Pong-soo, we will cover the Labor Union Act Article 46, which is the requirements for lockout of workplace. So could you first explain about the concept of Article 46?
Hello, how are you today? This is Pong-soo Jung, Korean labor attorney. So lockout in the labor dispute means employer lock out. That means they refuse to receive the working from workers. So in this situation, employer decide to hold the lockout strike. So it is designed to protect the company and plant. Also, at the same time, they can save the salary, labor cost, while they operate, implement lockout. Then employer will not pay any money, any wage to workers. So, but in the legal requirement for lockout is employer can implement lockout after the labor union go on strike. Also, they must report their lockout plan to administrative officer and labor commission, each respectively. Then lockout is accepted as justifiable the strike by the employer. So this lockout is a preventive or offensive way to protect their company. If employer start to implement lockout before labor union go on strike, then it is illegal lockout strike.
So in case the employer decide to lock out the workplace, this is only when the labor union start the industrial action. So could you explain the category? There are several categories that is classified in the industrial action.
Yes, so this lockout is the one way for employer to protect their workplace from union strikes. So when union go on strike, that means they collectively refuse to provide the labor service. Then in employers' perspective, those people who do not participate in strike, employees still they have to pay while the company cannot operate their business. Then it is huge the loss of the labor cost while they do not have any production. So this legal requirement is when union start to go on strike, then employer they implement the strike. So also when labor union the refused and they stop going on strike and they announce they will come back to workplace, then company should announce so they cancel the lockout. If they continuously hold their lockout, then it is regarded as illegal lockout strike. Then employer should pay salary during the illegal lockout period.
So if the labor union start the industrial action and the employer decide to lock out the workplace, this is a big loss for both sides. And true. Especially if the company cannot make revenue, it's both loss for the workers too. So I understand you have experience of negotiating between the employer and employer labor union. So could you introduce some examples?
So I was involved in labor dispute as a chief negotiator for the company. So this company located in the Pohang, the city. Pohang is famous for POSCO, the iron production company. So this company was a manufacturing company. At the time, there were the labor disputes. So union went on strike. So I think union's demand was not something employee could not accept. So then they took on general strike. So employer after 30 days, union went on strike. They announced and they implemented the lockout. So the company announced to the union members, you should come back to save a company, but they continually staged the strike. Almost it was 2 months. So company suffered from the loss of their market. So, but union key union members, the persuade all workers not coming back to work. So, but workers they could not survive without earning. For when they went on strike for 2 months, they could not earn any money. So they worked as part-time for other company, but the salary was 1/3 of that used to earn. So they felt very sorry for. So union members refused to go on strike anymore. So they decided they pushed the key members. So the union gave up the holding strike. So they announced they would come back to work. So it was solved smoothly. After they returned, company could manage some collective bargaining smoothly with union members, and they conclude the collective the bargaining. So it was a good lesson for employer and union. I mean the labor union. So if they go on long strike, it is suffering or it is not helpful to either party. So probably even though the company lost a lot of production, also union members could not earn any money. So I'm sure in next collective bargaining session, they will not take such a long strike, but they will get some compromise before they go on such a long-term strike. Yeah.
I think your example, the introduction of your example, gave a lesson for especially the labor union side and also maybe employer side. And I think it's very important that the labor attorney get involved to so that the dispute make a conclusion for both sides. Do you agree?
Yeah. So I experienced it. Even I have experienced such a labor dispute, especially it's a long-term lockout and long-term strike. It was first time I experienced. Most cases it was resolved. It was finished within 1 month. But this labor union took 2 months long strike. It was very negatively affected to both sides. So probably when I have a chance to deal with, I trained both sides. It is not beneficial both sides. Also, even during the strike period, some of union members they were engaged in like destruction for company production line. So it became a criminal issue. So there were some civil claim against those some workers who were committed such violent cases. So I saw some terrible cases. So probably some following rule within the boundary is very important. That's what I realized very seriously.
I think its timing is also important for the settlement, especially when 2 months strike goes on. The workers cannot earn as much as they used to, and also from the employer's point of view, they will lose money if they cannot manufacture their product.
Yeah, that's true. Yeah, it was a good lesson. Both sides, like employer and labor union members, learned by harsh way. But I'm sure it will be a good medicine for next time, the labor dispute. Yeah.
Thank you very much.
Okay, thank you for watching. Okay, bye bye.